If you live in the UK, you've probably heard of a company called Argos. If you don't live in the UK, it's quite a big company. It's now owned by Sainsbury's, whatever the Sainsbury supermarket group is called now. I've purchased quite a lot of things from it over the past few years, including in October 2023 a new gas cooker, which cost me several £100. I've no complaints with the company. Mostly I bought these things from the Sainsbury store in Penge. But on April 21st, 2025, I purchased two 256GB memory sticks from the store. Their actual capacity appears to be about 232GB, but I'm not complaining about that. I was given a receipt. Now, normally when I buy something, I've been online banking for a few years, as most people have now. I keep receipts for my debit card purchases, and then I throw them away, which I did. On April 23rd, the first of these two memory sticks failed to copy properly. It was clearly defective. This is something which is quite common with this technology. I would advise anyone not to buy memory sticks from eBay. I've made that mistake. I thought Argos was the best place to buy them. Anyway, I returned this memory stick, and the sales assistant said I need a receipt. When I told her I'd dispose of it, she gave me a piece of paper. This piece of paper here, there it is. There's a scan of this piece of paper and all the relevant documents at the Internet Archive. I'll put a link to that, to the page which contains all the documents. Anyway, when I phoned this number, I received only an automated reply which asked me to give a receipt number. I managed to get through to somebody, a real person, instead of Cortana or whatever the Argos uses, and I didn't get the receipt number. In the meantime, the second memory stick also proved defective. Buy cheap, pay twice. So I returned this, and I took a printout of my bank statement. I was told again by the sales assistant, you need a receipt. She refused to accept the bank statement as proof of purchase. So, I had enough of this. I wrote to Argos Complaints Department. One of the wonders of living in London is that most of the big companies of this country, and quite a few others, are located here, usually quite central. I wrote this letter, delivered it by hand to their office, and I asked for a full refund and £30 compensation for the time and effort I'd wasted. A total of £75. On May the 8th, happy birthday Candice, that's another story, I received an email from Chris Stockton. No, was the answer I received. No, we won't give you a refund. There was actually more than one email between myself and Mr. Stockton. Again, that's in the file, on the page of the Internet Archive, Baron v Argos. I said, look, if I don't get this 75 quid, I'm going to sue you. And I gave him time to consider this. By the end of the month, I said. And when I was ignored, I sued Argos, through the county court, Croydon County Court. The summons cost me £30. What happened next was truly amazing. Instead of conceding that they'd made a mistake, they were in the wrong, whatever, their legal department decided to defend this claim. a bloke named Faisal Mohammed, paralegal. And would you believe this dude actually put his pronouns in his email signature? And he tried to blind me with legal jargon. I actually sued in the county court before and won. I mean, when I say won, I mean judgment. I've sued in the High Court as well and won. Judgment. Not something I like doing nowadays because it's expensive. Since the so-called Wolf reforms of the 1990s, was meant to litigants in person, especially, they complained it was very expensive to sue. Well, people who ended up being litigants in person because they could afford lawyers. And Lord Wolf, who was then Master of the Rolls, was given the task of reforming it, and well, you're no longer a plaintiff, you're a claimant. But apart from that, it's ludicrous. Ted Goodman, now deceased, he complained about it. They said that the rules were ridiculous. People were getting claims struck out left, right and centre. Defendants as well as plaintiffs, claimants. Anyway, Mr. Mohammed tried to blind me with science, with legal jargon. He made a mistake. And his defence, which runs to 5 pages, I was really of two minds to report this guy to his legal body because it's full of lies. I'll just go through it a bit. The claimant failed to send a letter before action as per the pre-action protocol. This would have allowed for the matter to be fully investigated by the defendant before the claimant having to resort to issue a claim against the defendant. Well, this is complete nonsense. As I said, I wrote to the company and I had some email correspondence with Mr. Stockton of the complaints department, so called. I said, pay me by the end of the month or I'll sue you. That is a pre-action letter, pre-action email if you want. It's pre-action. So that is a complete lie. My last email to Stockton was actually on May the 9th, 1621. Dear sir, I'm not prepared to discuss this matter any further. If I don't receive a full refund plus compensation by June the 1st, you can expect a writ later the same week. I will leave you personally to explain this intransigence to your board of directors and the result of bad publicity. That is my final word on the matter, signed A. Barron. Ignored. Faisal Mohammed goes on to say, the claim centres around a return of a memory stick which could have been resolved with other options without the need to resort to court action. 2 memory sticks. I did everything else I could. Did everything. I contacted the store, gave them proof of purchase, and I was starting to go pound sound basically. The premature issuance of this claim contradicts the spirit of the pre-action protocol. Does it hell? The claimant's conduct has hindered proper resolution and has added unnecessary cost to court time. How is it? You have plenty of time. May the 9th till the end of the month. Did Stockton send an email? Did he phone the store? No. He says the particulars of claim are defective. No, they're not. The process you go through is a bit confusing. You put the statement and then on the form, and then you can serve a far more particularised claim. The county court isn't like the high court. It's done. It's so that lay people can litigate. As I said before, people have complained for years about the expense of litigation. The county court isn't like the high court, even after Lord Wolf. As per the rules, the claimant should prove a concise statement of the facts on which the claimant relies. Instead, the claimant has just stated, this will be included in my supporting affidavit plus exhibits, which I did. You can see them yourself on the Internet Archive. The particulars of claim are unclear, incoherent, and do not disclose a valid cause of action. Nonsense! Absolute nonsense. The claim should therefore be struck out. No! As it discloses no reasonable grounds for bringing the claim as an abuse of process. Complete rubbish. It's perfectly clear. And how is it incoherent? You sold me defective goods and I want a refund. The claimant alleges that he purchased a PNY 256GB memory stick from Argos and that the item was defective, more than one. The claimant further alleges that Argos refused a refund on the grounds that he did not have a receipt. He is now claiming for the cost of the item and £75 and interest. Proof of purchase is required under law and terms and conditions. Well, I did give proof of purchase. Under the Consumer Rights Act, consumers have the right to a refund within 30 days of purchase if the goods are faulty. Yes. However, the law requires that the consumer must prove the contract of sale, i.e. they must provide evidence of the transaction. How much more evidence do you want? Here, look. I've still got the memory sticks. Here they are. Not very clear on here, but you can still see on this one, you can see the store code or whatever it's called. Problems with this camera. Yeah, that's an internal code. Oh, on this one as well. That's barcode, whatever. I mean, that's proof. You know, I've got the bloody things. I took them back, and they said no. So how did I give proof? And he goes on again. However, the existence of a contract must be established. It is established. Furthermore, I signed a statement of truth, which, unlike yours, Mr. Mohammed, contains factual truths. Without proof of purchase, there's no legal basis to exercise these remedies. Well, you got the proof of purchase to exercise remedies. It goes on further here. No evidence the item was faulty. The claimant alleges the item was defective but has not provided evidence of the fault or return the item for inspection or testing. I did! They said no! And as I say, I've signed a statement of truth to that effect. These heads of loss are speculative and unsupported by evidence or legal principle. Really? The county courts do not award costs for time, effort or research expended by litigants in person, except in limited circumstances, which are not applicable here. They are. They were. There is no legal basis for compensation unless specific financial loss or distress has occurred and been evidenced, which is not the case here. Wrong again. Conclusion. The defendant acted in accordance with its terms and conditions, consumer law and industry best practice. No, it didn't. Claim is therefore without merit, exaggerated, and should be dismissed. In light of the above, the defendant respectfully requests the court strike out the claim. In alternative to dismiss the claim in full, reserve the defendant's right to apply for costs where appropriate. In other words, you can apply for costs, but I can't. Anyway, I replied to the defence, which I've just gone over what I said there. In the county court, now, mediation is compulsory. I had a call from mediator, and initially they offered me a refund of £38, whatever it was. I said no. No, I'm going to court for this. Shortly before the case was to be set down before District Judge Keating, I got an email from Mr. Mohammed offering me £70.98. My response was, how can I put it? This is what I wrote in an email. This is dated November 19th. Dear Mr. Muhammad, you continue to add insult to injury. I don't know how much you've spent so far defending this indefensible claim. It must run into hundreds at least, and you've already destroyed the goodwill of a regular Argos shopper. But I will not settle for a penny less than on my writ. Furthermore, after I win this case, and I will win it, I will shout the judgment from the rooftops. Then you and your complaints department will have to explain to your board of directors and shareholders why you've acted so. In your spurious defence, you sought to blind an inexperienced lay litigant with legal jargon. Alas, I am not so inexperienced because I have litigated both the County Court and the High Court before and won. I also acted as a Mackenzie friend, reported on court cases, and even done process serving. I expect this sort of behaviour from the police and government departments, even from the RSPCA, who fought Heather Illott over her mother's contested will, but not from one of the biggest and most reputable companies in the country. Reputable at the moment, I will see you in court. The bottom line is that I got everything I asked for, and here's the proof. I left a review on Trustpilot, and somebody from the company noticed it, read it, replied, but I've had no real apology. And I will not be shopping at Argos again if I live another 10 years, which I very much doubt. Anyway, that is what you can expect from Argos. What I didn't expect, and really I'm extremely disappointed. You expect that sort of thing from, I say, government agencies, include the police, from so-called non-profits, anyone who's paying out of their own pocket, but not from a company, and not from a company this size, and one which is supposedly reputable.